Welcome to the first Friday lunchtime talk of the term. We have a tradition that the first one in each termly series is a kind of special honor that we bestow upon the speaker. The first one is always a slightly special lecture, and it is a great pleasure that this privilege has fallen on Greg. Professor Greg Fox is a senior professor, as you know, at Wayne State University. He is a member of the American Law Institute, and he has just told me that in the sign of times, in the upcoming fourth edition of the restatement that they prepare for our guidance, they're dropping the chapter on international law. So that is very sad to hear. But otherwise, he has been a wonderful contributor to many of our edited books and other works. You were here last in 2018, I think you mentioned. So we have a long-standing and very much appreciated relationship with Greg. He works very much on issues after my own heart: statehood, governments, legitimacy, recognition, peace settlements. He's just completing a work on the legal status of civil war, internal or semi-internal peace settlements, which is a somewhat gray area where clarification of the law is much appreciated. Of course, when we scheduled this talk, we knew that Mr. Trump would make Ukrainian peace within 24 hours. So we expected that the deal would be in hand by the time he speaks. But sadly, it's now 100 days. So, Greg, before you leave us, you may have to speak again and give us the updated edition of your talk in relation to the agreement that is coming. Greg's focus is really an interesting one. In order to make peace, sometimes it is felt that you have to make sacrifices in terms of general international law, and the debate most often arises in terms of immunities or other grants that are given to participants in the conflict in order to persuade them to sign on the dotted line. And the far greater question is, of course, what do we do when a peace agreement seems to endorse the outcome of an unlawful use of force? The cardinal sin in international law, the uncontested highest order jus cogens obligation. And as you know, the outcome of a serious violation of peremptory norms is threefold for all other states: non-recognition being the first one, not to assist the offending state in maintaining in place the result of the violation, and thirdly, to work through international institutions to try and reverse the consequences of the aggression. And a peace agreement kind of seems to do the opposite. It seems to ratify the outcome of the conflict. So I am very keen to hear the presentation. Some of you may have seen a preview in EGI talk of his article. And there's another scholar who I think took a slightly different position to yours. And therefore, it's with great pleasure that I invite you to take the floor. Thank you.
Well, thank you very much, Mark. It's a great privilege to be here. This is an extraordinary group of people that are assembled at the center, and it's a real honor for me to come back and to be able to present what for me is a fairly new project and to get your thoughts and feedback. So thank you very much. I should begin with a few caveats. The first is that I have no particular insight into the state of peace negotiations, if in fact they are recurring at all, or any reliable predictions about what a final peace agreement will look like. So other departments of the university may be better at that. But what I am going to do for purposes of this talk is to assume that there will be a peace agreement, that it will provide that it is a binding treaty under international law, and that at its center, the agreement will involve transfer of some portion of territory now generally recognized to be Ukrainian to the sovereignty of Russia. And my talk will focus mostly on that provision. As Mark mentioned, I did write a piece in EGL Talk that focused on a few other potential provisions in a peace agreement, one having to do with amnesty from the extant ICC prosecutions now going on against President Putin and several of his colleagues. And one might expect Russia to seek amnesty for those and other crimes, and also the possibility of mass population movements in the agreement. I'm happy to talk about those possible provisions in the Q&A, but I'm not going to address them in my main talk. The last thing I'd like to say as a preliminary matter is that this will be a very practical talk. What I am trying to do is imagine the types of discussions that are almost certainly now going on in foreign ministries around the world about the contours of a peace agreement, what legal obstacles might exist to coming up with one that is compatible with international law, and how those obstacles might be overcome. Those issues, as I think we'll see, do raise quite a few deeper and broader questions, but the discussion will be on that level. So to begin with, I want to start with the question of where one finds law regarding peace agreements, since we are talking about the place of peace agreements in international law. Where would we find treaty law? Where would we find state practice? And those are difficult questions to answer for at least two reasons. The first is that there is just very little recent state practice on international peace agreements. And here, and Mark mentioned this a little bit, I need to distinguish between peace agreements in international armed conflicts, or IACs, and peace agreements in non-international armed conflicts, or NIACs. As Mark mentioned, there's quite a bit of controversy about whether NIAC peace agreements are in fact treaties, because by definition, one of the parties is a non-state actor. And as most of you probably know, the definition of a treaty in the Vienna Convention requires that it be an agreement between states. I've written about that. I'm happy to talk about it, but I'm not going to talk about NIAC agreements. We just don't have very many IAC agreements because we just don't have very many IACs. Here's a chart of armed conflicts by type from 1946 to 2023, and the very small blue band at the bottom is interstate armed conflicts. As you can see, they make up just a minute percentage of all armed conflicts and have for quite a long time. If there aren't many interstate conflicts, there are not going to be many treaties ending interstate conflicts. Data specific to interstate peace agreements is a little bit hard to come by, especially if one wants to take a long historical sweep. What I can provide you is one very kind of idiosyncratic data set from the American international lawyer Quincy Wright, who here tells us that while peace agreements were quite common up until the First World War, they virtually disappeared after the First World War. I've been unable to, and he wrote this in 1970. There's a little bit of a gap in the data. We can then pick it up in 1990 from the Peace Agreement X data set, which is maintained by the University of Edinburgh. And during this period, there were only 7 IAC final agreements. There's some preliminary ceasefires and things of that nature, but final comprehensive agreements purporting to settle a conflict in total, very, very few. And I guess you can see why I've started writing about NIAC agreements, because that's where the is. What about state practice? One interesting place to look for how states think about peace agreements is national military manuals, which have policies related to almost all aspects of armed conflict. And there, I think the lack of centrality of peace agreements becomes pretty evident. The U.S. Department of Defense Law of War Manual, which was newly revised in 2023, spends exactly 2 pages on the termination of armed conflicts. The document itself is about 1,000 pages long. The UK manual actually provides a really wonderful illustration of how irrelevant peace agreements have become to states' policies on armed conflict. If one goes to the index of the UK manual and looks up peace treaties, what you find is a subheading under peace, and the reference is to one footnote. That's it. So we don't have very much in the way of state practice. Well, that's on the, kind of a realm of what is happening out in the world. But there has also been an enormous shift in international law. Peace agreements used to be absolutely central to what was called the law of war. If one picks up a treatise from prior to 1945, one would find entire chapters on peace agreements in various aspects. Obviously, peace agreements were important for the specific provisions that they provided, but in general, peace treaties performed what I've referred to as a signaling function. That is, they told the rest of the international community that a transition had occurred from law applicable in time of war to law applicable in time of peace. And there was a whole specialized body of international law applicable only during times of war. The most famous is the law of neutrality, but other areas of international law also had their special regimes. Treaty relations between belligerents and sometimes between neutrals and belligerents might be suspended or terminated. There was law having to do with the status of enemy aliens, law having to do with the retention of enemy property and territory. International actors needed to know which legal regime was applicable, and peace treaties performed the function of telling them what it was. It's quite interesting to look, for example, so just as an illustration of this, here's Oppenheim's second edition, saying that the chief effect of a peace treaty is the restoration of the condition of peace between the former belligerents and all of the attendant legal change that involves. Early editions of Oppenheim take what to, I think, contemporary eyes is an inordinate amount of time discussing the effective date of a peace treaty. Who cares, really, what the exact date is? But if you think about the signaling function, it becomes absolutely critical. This is the point of transition. I think it's fair to say that the signaling function has passed into history. The bodies of law that would regulate armed conflict, the jus in bello, the jus ad bellum, state responsibility, human rights law, do not depend on formal statements or formal policies of states involved. Rather, almost uniformly, they depend on factual determinations on the ground. And so if the law doesn't require a signal, the primary instrument providing that signal has ceased to serve a useful function. There are several other reasons, that you can find in the literature for the decline of IAC peace agreements. One of them that I think is just particularly interesting for us is that at least in some cases, the function of a peace agreement, specific function of a peace agreement for the belligerents, has been taken over by the UN Security Council. So if you think about Resolution 687 ending the Iraq-Kuwait war, its provisions on disarmament, recognizing borders, the return of prisoners, et cetera, are all things that in a previous time one would have found in a peace treaty. But the Security Council has more or less imposed them on Iraq under Chapter 7 of the Charter. So I think it's fair to say that today, and this is all coming to this conclusion, there is, in fact, no specific body of law governing peace agreements. Rather, it is these other cognate bodies of law that will inform our discussion. I will be speaking mostly about the law of treaties, but there are certainly others that are applicable. Okay, well, with that background, let me talk about two possible grounds that might be asserted for the invalidity of a peace agreement between Russia and Ukraine. And again, keeping in mind that I'm going to assume that at the center of such an agreement would be the transfer of territory. The first is the problem of coercion. There is a basic principle of treaty law that a treaty is void, as we were looking at Article 52 of the Vienna Convention. A treaty is void if its conclusion has been procured by the threat or use of force in violation of the principles of international law, in violation of the Charter of the United Nations. I'm sure you know about equivalent doctrines of contract law, that if someone is threatened with violence or something else into signing a contract, that contract is void because it is not the product of the freely given consent of the person, and the same thing holds true of the state. Now, you might think, hearing that, well, aren't all peace agreements coerced? I mean, they come out of armed conflict, and the alternative to a peace agreement is more conflict, which can cause damage, which is a threat. Well, if we look carefully at the wording of Article 52, you will see that it actually makes a distinction between two types of peace agreements. A peace agreement is void if the threat or use of force that induces the peace agreement is in violation of the Charter of the United Nations. And we know the Charter of the United Nations prohibits aggressive force in Article 2.4, but we also know that there are two textually clear grounds for the legitimate use of force, that is self-defense and authorization from the UN Security Council. So what Article 52 ends up doing is creating a bifurcated regime. These treaties that are imposed on a victim state, that is a state that is the victim of aggression, would contravene Article 52 and would be considered void. On the other hand, treaties that are imposed on an aggressor state, which has not used force in violation of the Charter of the United Nations, would not be considered void. And the reason for this, I think, is fairly clear. The UN Charter obviously prohibits the aggressive use of force, but as Mark alluded to, it is also intended to preclude the benefits or fruits or result of the aggressive use of force, namely the acquisition of territory from a sovereign state. So there's a parallel, I think, between the jus ad bellum and the meaning of Article 52. I think it wouldn't be very difficult to make an argument that the only reason Ukraine would enter into a peace agreement that we've described is because of the unlawful use of force by Russia. Ukraine already had a guarantee from Russia in the Budapest Memorandum from 1994 that its borders would be respected. Russia has obviously violated that, and one can't imagine Ukraine under any other circumstances ceding portions of its territory to Russia, but for the use of force. In the fisheries jurisdiction case, the ICJ made a kind of passing reference to Article 52. It was an argument that was made but rejected. And the ICJ said, this coercion argument has doesn't fit the facts here because the agreement in question was, quote, freely negotiated by the interested parties on the basis of perfect equality and freedom of decision on both sides. That's more or less the polar opposite of what Ukraine would find itself in. Okay, so I think the fact of coercion is probably not all that controversial. What follows under the law of treaties if we find, or an individual state would find that the terms of Article 52 have been met? Well, the first thing that follows is that the entire agreement, as between Ukraine and the other parties, would be void. Now, one can imagine Russia agreeing to some provisions that would try to induce Ukraine to sign, to sweeten the pot. Perhaps the return of the children who have been more or less kidnapped from Ukraine into Russia. That was the basis for at least one of the ICC indictments, or some security guarantees. And so you can imagine Ukraine, trying to balance these two things. On the one hand, we get these benefits. On the other hand, we have to give up territory. The Vienna Convention seems to preclude that in the case of coerced treaties. In cases falling under Article 52, which we just talked about, no separation of the provisions of the treaty is permitted. That is, the treaty fails in its entirety. Second thing that would follow, and this to me is the most interesting and controversial aspect, is that the decision of whether or not to raise the question of coercion and therefore the treaty being void seems to be up to Ukraine. We look at Article 65, which is part of a portion of the Vienna Convention, which deals with the procedures to be followed if there's going to be a claim of a treaty being void. Article 65(1) seems to say that it is the state that is claiming coercion that must raise the claim. A party which, under the provisions of the present convention, invokes either a defect in its consent to be bound by a treaty, must notify the other parties of its claim. And what follows in the articles following 65(1) is a notice period, there's a waiting period, negotiations are encouraged, and then ultimately there's some dispute resolution provisions. But what Article 65(1) suggests in saying that the burden is on Ukraine to make this claim is that Ukraine might not make this claim. They might decide that it's too politically or militarily precarious to hold out for some more beneficial outcome in making the coercion claim, and they might withhold it. Now, you might think that that might be a good thing, right? Ukraine could hold back in its coercion claim. Maybe the situation stabilizes. Ukraine is able to rebuild, regroup, get some more assistance, and then at some later time, when they feel like they might gain military advantage, then raise the coercion claim. The treaty becomes void, and therefore, if they were to go on a military offensive, they could not be accused of violating a treaty, which is void. That sort of wait and see approach would seem to be permitted by Article 45, which we just looked at. And this part of Article 45 deals with losing a claim, waiving a claim of termination or invalidity, but notably a claim of coercion under Article 52 is excluded from this language. It is not waived. It can be retained. And so Ukraine might strategically try and do that. The circumstances might change on the Ukrainian side, but the circumstances might change on the Russian side. I have no crystal ball, but maybe there would be a regime change in Russia, or maybe the economic costs of the war to Russia would become so precarious that it became clear that they couldn't keep up the kind of current level of forward supply, and Ukraine might decide, well, now is the time to engage in a counteroffensive, and as preparation for that, we are going to invoke this claim that the void. The final procedural aspect of this is that all of those machinations by Ukraine don't necessarily get it out from under the shadow of the treaty. And that is because Article 69 of the Vienna Convention deals with, invalidity generally and says in paragraph 4, in the case of invalidity of a particular state's consent to be bound by a multilateral treaty, and again, remember I said that at the beginning that I'm going to assume that this is a multilateral treaty, the foregoing rules apply in the relations between that state and the parties to the treaty. So a coercion claim would void Ukraine's treaty relationship with all the other parties. Let's assume it's the E5 of the Security Council plus some other states, but it would not void the treaty relations between those other states. The United States and Russia and Britain and China and whoever else is involved would still be parties to the treaty, assuming they didn't invoke some other grounds for invalidity. And so if one is inclined to be cynical, one could imagine a Trump-led United States and Russia and some other countries continuing with the treaty, the central provision of which recognizes Russian sovereignty over some portion of Ukraine. That, despite Ukraine having left the treaty and no longer being bound by its obligations. The final thing to say on this issue is that it doesn't sit well with me that the burden of raising the coercion claim should be on Ukraine. I mean, the whole point, presumably, of Article 52 is to regard certain types of consent as not voluntary, that, the state is facing an untenable choice between, kind of military annihilation and accepting a loss of its territory or some other form of external domination. And the function of Article 52 is to not take that consent at face value, but putting the burden on Ukraine to raise the coercion claim does seem to validate coercion that should be seen as void ab initio. And I'm interested to hear what people think about that kind of problematic aberration of the coercion doctrine. Okay, that was all ground number 1 for avoiding the treaty. Ground number 2, and this may be a little bit more controversial, is conflict with jus cogens norms. I assume that most of you are familiar with the idea of peremptory norms or jus cogens norms. These are, kind of foundational principles of international public policy that are so fundamental that states cannot engage in violation of them, even if they agree to do so consensually. So, 2 states could not enter into a treaty to commit genocide in a third state, even if that treaty was negotiated at arm's length with no problems of it being entered into. A peremptory norm or jus cogens is defined in Article 53 as a norm accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted and which can only be modified by a subsequent norm of general international law having the same character. I also think it's rather uncontroversial that the prohibition on aggressive force is kind of the quintessential jus cogens norm. It's been recognized by the International Law Commission in numerous cases. Most commentators agree that that is a jus cogens norm. So I don't think that there's much controversy there. I'll get into what exactly that norm entails in a moment. I also don't think it's controversial that Russia's invasion of Ukraine was an unlawful use of force. For obvious reasons, the Security Council has not pronounced on that, but the General Assembly did, pursuant to the Uniting for Peace formulation. And here's an excerpt from the resolution from March of 2022, specifically saying in paragraph 2 that Russia's use of force violates Article 2.4 of the Charter. So we would have an agreement that was brought about by the unlawful use of force. Would that be the necessary conclusion? Well, an objection might have occurred to you in thinking about this. And that objection would be that the peace treaty, as I've described it, would not prescribe or contemplate the use of force. At most, you can say a peace treaty would ratify as a fait accompli a prior use of force. This is the outcome of an unlawful use of force, not the unlawful use of force itself. It would be very different than, for example, a treaty by which two states agreed prospectively to invade a country and then divide it up between them. Is this a problem? I think there are at least two responses to that objection. The first is to say that annexation, which is really what Russia would be engaging in, only occurs after the aggressive use of force. And so while obviously the two involve different acts at different times, first you have the force, then you have the annexation, conceptually they are the same thing. And one might draw support for this from the ICJ's advisory opinion on the occupied Palestinian territories, where they describe territorial acquisition as a corollary to the prohibition of the threat or use of force. A little bit later in the opinion, the court says that the legality of continued occupation is governed by the jus ad bellum, which is the law governing the use of force, again suggesting that the two are inextricably linked. Okay, what is that response adequate? I think there's room for doubt. In their separate opinion in the OPT case, Judges Nolte and Cleveland went to some lengths to try and make clear that the court's conclusion that the occupation and de facto annexation did not mean that Israel's initial use of force was itself unlawful. They argue that in 1967, Israel acted in self-defense, in legitimate self-defense. And the fact that the continued occupation, taking the form of annexation, violated international law, did not invalidate the initial use of force. In other words, Nolte and Cleveland separate annexation from the initial use of force and say it doesn't necessarily follow that annexation always is a consequence of aggression. It can be the consequence of self-defense. This idea that the two are separate is supported by an article that many of you may have read by Monica Hakimi and Ingrid Brunk in the American Journal of International Law, focusing on the prohibition on annexation and making a very detailed argument that historically and conceptually it is quite different from the prohibition on the use of force. We can talk about whether you think that that's a valid argument or not. Okay, so that's one response to that problem. The second response to the problem that the treaty itself does not involve the aggressive use of force is that to say that the prohibition on annexation is a separate, entirely freestanding jus cogens or peremptory norm. There is very little law or practice on this. This is the subject of Brunk and Hakimi's article. I recommend it if you'd like to see the details. One interesting kind of recent development that they actually pointed to in a blog post is that if one looks at the memorials submitted to the ICJ in the Palestinian case, virtually no state makes the argument that annexation is itself a freestanding jus cogens norm. Rather, the argument, the jus cogens argument is either about the unlawful use of force or more commonly, the Palestinians' right of self-determination. And so there was a perfect opportunity for states to weigh in on this issue, and they chose not to. My view, for whatever it's worth, is that while there might be a paucity of state practice, it's very, very hard to say that one accepts a jus cogens norm on the prohibition of the use of force, but not one on annexation. Both of those prohibitions really are grounded on protecting the territorial integrity of states. One can argue that a prohibition on annexation is more protective of the territorial integrity of states. And so if one accepts that as the justification for one peremptory norm, it's very difficult to say that the other one doesn't exist. the final thing I would point to is that one of the few times the Security Council has addressed this question, it seems to use language that is very similar to language of use Kogan's. So this is one of the early resolutions that the Security Council passed in 1990 after Iraq invaded Kuwait and purported to annex Kuwait and make it one of the provinces of Iraq. And the Security Council says the annexation of Kuwait by Iraq under any form and whatever pretext has no legal validity and is considered null and void. That sounds like the language of a peremptory. Okay. I don't want to talk too long, but there is one more issue that I think we need to address, which is whether the Security Council can validate a peace agreement, notwithstanding all of the problems that we have just discussed. That is, could these problems be quote unquote cured by a Security Council resolution under Chapter 7? And, this view would regard Chapter 7 as something of a magic wand. You have a messy legal situation, lots of arguments based on not clear doctrine about whether a treaty would be valid or not. The Security Council waves the Chapter 7 magic wand, and poof, all of a sudden we have a set of legal obligations that do not depend for their validity on the peace agreement being okay or not. There are obviously lots of things we can say about the political likelihood of the Security Council passing such a resolution, but let's put that to the side and talk about the question of whether the Security Council can, in fact, do this. Could the Security Council cure these defects? And I think that there are two different ways to look at this question. First is from the perspective of the superiority of council-imposed obligations to treaty obligations. This is clearest in Article 103 of the Charter, which provides that in the event of a conflict between obligations of the members of the United Nations under the Charter and obligations under any other international agreement, their provisions under the present Charter shall prevail. Article 103 would seem to create a hierarchy between obligations, which would include Chapter 7 obligations and pre-existing treaty obligations. The Security Council has a fairly robust practice of altering states' pre-existing treaty obligations. Probably the most famous one is in the Lockerbie case, where the UK and the United States sought extradition of two suspects from Libya in the Lockerbie bombing under the Montreal Convention, which all three states were parties to. Libya had the option to try or extradite. Libya said, okay, we'll try. And the Security Council passed a resolution more or less saying, not good enough, you have to extradite. And in the provisional measures opinion, the ICJ sided with the Security Council over Libya's objections that its Montreal Convention rights were being trampled. Other examples include in the case of the Somali pirates, the Security Council essentially redefining piracy as it appears in UNCLOS from occurring solely on the high seas to also occurring within Somali territorial waters. And then in the case of the occupation of Iraq, the Security Council designated precise dates on which the occupation started and ended, which is quite contrary to the mechanism in the Hague regulations, which is a factual question. Is there effective control over the territory by the occupying state? So those resolutions seem to be, this magic wand that I mentioned. But I'm not sure that the argument from this perspective would really help in the case of a Ukraine peace agreement. And that is because the treaties that I've just described and that are presumably contemplated by Article 103 were in force. There was no question that they had been validly entered into by all of the states concerned. In the case of an Iraq peace agreement, however, that is the very question. Is this a valid treaty? And so the Security Council would not be preempting one extant legal obligation by imposing another. It would be
creating a legal obligation where the law of treaties would say that none existed before. And here I'm impressed by an argument from Stephen Tellman, who says that such an action would essentially involve the council redefining a treaty under international law. An essential element of treaties is the voluntary consent of states involved, and a Security Council resolution, as I've described it, would kind of remove that requirement. And Tellman says there's nothing in the charter itself or in council practice that would allow council the council to essentially, create a new form of international obligation. Finally, in this on this question, having the council or allowing the council to impose a treaty on Ukraine would seem to contradict the logic of Article 75 of the Vienna Convention. There's a special clause here having to do with the treaties of aggressor states. And Article 75 provides that the provisions of the present convention are without prejudice to any obligation in relation to a treaty which may arise for an aggressor state in the consequence of measures taken in conformity with the Charter of the United Nations. Article 75 is essentially creates a special regime for peace treaties. And it's a carve out from Article 52, the coercion article, and the reference to obligations that may arise. Obligations, if you want to look at the drafting history, have to do with measures to implement a peace agreement. So disarmament, for example. An aggressor state cannot raise a coercion argument against the council taking those measures. By negative implication, one would think, there is not a carve-out created for victim states, such as Ukraine. So the council is not given these extraordinary powers if it's dealing with a victim rather than an aggressor. Now, there is a potential way around these objections, and there is precedent for it. Instead of the Security Council passing a resolution that more or less says a peace agreement negotiated by Ukraine, Russia, and other states is valid, it would be to take the terms of the peace agreement and simply put them in a resolution and impose that on Ukraine. And the a precedent for that is Resolution 1373 from 2001, which more or less takes the Convention on Terrorist Financing and imposes it on the entire international community. The Convention on Terrorist Financing at the time was not even in force. Very few states had ratified it, but the Council put its terms or its central terms into a Chapter 7 resolution, and it became law for all states in the international community, even those who never intended to become party to the treaty. Maybe that could happen. We need to conclude. Okay. Let me just say one more thing. If the argument for a council override or cure, specifically in regard to the Jus Cogens objection, works only if one concludes that the council itself is not bound by Jus Cogens norms. And that's a controversial position. The International Law Commission has taken the view that Jus Cogens norms do bind the decisions, do govern the decisions of international bodies. If the Security Council cannot transgress a Jus Cogens norm, then it cannot validate a treaty which transgresses Jus Cogens norms. It has no superior power. So the only way for the Council to overcome that objection, in my view, would be to conclude that the Council itself has essentially unlimited legislative authority. Let me stop there, and I'm sorry for going on too long.
Not at all. Thank you so much.